Welcome back to the Federal Disability Review Academy. I'm Emily Hall, founder of the Federal Disability Review, and in this lesson, we answer the question most people bring here first. Who is actually eligible for federal disability retirement? Here is the honest starting point. This benefit is available at any age, but that does not mean every federal employee with a diagnosis is eligible. So let's walk through what eligibility really looks like, gate by gate. In plain English, a federal employee's retirement system covered employee may qualify when a long-term medical condition prevents useful and efficient service in their own federal position through performance, conduct, or attendance, and the agency cannot solve the problem through reasonable accommodation or a qualifying reassignment. Notice what that sentence is really saying. Eligibility is about your position. It has never required being unable to do every job in the economy, and it does not require being bedridden. Keep that in mind as we open each gate. Gate 1 is service. You need at least 18 months of civilian service creditable under the Federal Employees Retirement System. That's it on time. There is no minimum age. This is one of the ways disability retirement is different from regular retirement, which is built on age and years of service. But I want to be careful with you here, because this gate is where a common myth starts. 18 months does not mean every federal employee qualifies after 18 months. It only opens the first gate. Every other requirement still has to be met, because these requirements are cumulative. You need all of them, not some of them. Gate 2 is timing. The disabling condition must arise while you are employed in a position subject to federal employees' retirement system. And here is something that surprises people, especially those who have already left. Separating from federal service does not automatically close this door. A former employee can generally file within 1 year after separation, but the condition still has to trace back to the time they were covered. If you left federal service while you were struggling medically, this gate may still be open for you. Gate 3 is the heart of the whole framework. The disease or injury must cause a deficiency in your performance, your conduct, or your attendance, or be otherwise incompatible with useful and efficient service or retention in your position. Let me slow down on this because it holds two things people miss. This is not a total disability standard, and it is not a diagnosis-only test. A condition that mostly shows up as attendance problems, safety concerns, stamina limits, or cognitive strain can matter just as much as an obvious physical inability. And you can even have acceptable performance ratings and still face a genuine medical incompatibility with your job. What OPM is looking for is the connection between your documented restrictions and your actual position, not a label and not a rating. Gate 4 is duration. The condition must be expected to continue for at least 1 year from the date the application is filed. Notice the word expected. This is a prognosis requirement, not a permanence requirement. Your condition does not need a permanent label, but it works the other way too, and I'd rather you hear this now. If you're expected to fully recover from, say, a surgery within 4 months, this gate may not open, even though the situation is genuinely hard right now. Gates 5 and 6 belong to your agency, and they are two different questions. First, can reasonable accommodation in your current position resolve the disabling problem? If it can, disability retirement is not the answer. Accommodation is. Second, the agency considers whether a qualifying vacant position exists for reassignment. And here I want to correct something you may have heard, because it causes real fear. It is not true that any job offer defeats your eligibility. The regulations set specific criteria a reassignment has to meet. What is true is that declining a valid qualifying offer can affect eligibility, so this step deserves care, not panic. The last gate trips people up because it sounds backwards. A disability retirement applicant must also apply for Social Security disability benefits. You do not need SSA to approve you. OPM and SSA apply different standards, and OPM can approve you even if SSA says no. But the application itself is required, and withdrawing it can cause your application to be dismissed. So think of it as a required companion filing, not a hurdle you have to win. Other side, because knowing what does not establish eligibility protects you from painful surprises. A diagnosis by itself does not do it. AVA disability rating, even 100%, does not do it, because VA and OPM apply different legal standards. An approved SSDI claim doesn't. An accepted workers' compensation claim doesn't. And heavy use of sick leave or FMLA doesn't, unless the record ties those absences to the condition and the position. Even a supervisor telling you that you should retire is an opinion, not eligibility. None of this means those facts are worthless. It means each one has to be connected to the framework we just walked through. Let me make this concrete with two pictures. Picture an employee with more than 18 months of service who develops a neurological condition causing unpredictable vertigo, cognitive slowing, and repeated absences. The restrictions are expected to last beyond a year, the essential duties can't be performed reliably even with accommodation, and no qualifying reassignment exists. Every gate we discussed is in play. Now picture an employee with a diagnosed back condition, but a file that never explains any functional restriction, any duty conflict, any attendance problem. The diagnosis may be completely genuine, and the person may be truly hurting, but the label alone doesn't open the gates. The difference between those two pictures is not how sick someone is. It's whether the evidence connects the condition to the position. So here is where we've landed. Disability retirement is available at any age with 18 months of creditable civilian service when a condition arising during covered employment prevents useful and efficient service in your position, is expected to last at least a year, can't be resolved by accommodation or qualifying reassignment, and you've applied for SSDI. All of the requirements together. And remember, only OPM decides eligibility, and only after reviewing the complete facts and evidence. This lesson helps you recognize whether you may fall within the framework. Now that you know who may fall within it, the next lesson explains who is not eligible and the situations that commonly fall outside the program. If you need guidance specific to your situation, you can learn more about my consulting services through the Federal Disability Review. I'll see you in the next lesson. This material is provided for general educational purposes and is not legal, medical, tax, or financial advice. It does not create an attorney-client relationship or a consultant-client relationship. FERS disability retirement decisions depend on the complete facts and evidence in each case.